Good morning, or good afternoon, I should say. Depends where you are. My name is Steven Boyne. I am an attorney with the Florida healthcare law firm. I provide a lot of sort of general counsel advice to healthcare entities and cover a sort of a very broad range of items. My background is I've worked for large um, healthcare insurance companies. I've also worked for medical providers, air ambulance companies, and other large um, healthcare staffing companies. So my background essentially is corporate law with a strong IT bent, healthcare bent, and insurance, both from regular insurance and healthcare related insurance issues. Today, I'm really going to talk about conducting operations during a pandemic, which is the COVID-19 pandemic, obviously. We're going to, I have about 10, 11 slides to present. There's a lot of information in here, and I'm going to move relatively quickly. And essentially, my purpose here is just to sort of touch on items to make sure at least you've thought about them. I'm going to provide some solutions to some issues, some suggestions, and other areas with respect to certain items may be too complex for me to touch on today during our hour together. The the seminar is going to be presented into basically divided into 10 different sections. Let's hit the slide. There we go. Okay, so today we're going to talk about employment issues, real estate issues, insurance, travel, telehealth, PPP, Paycheck Protection Program, and lawsuits that have been already filed or have been resolved. Employment issues. As many of you know, we this time last year when the world started to deal with COVID-19, a lot of companies initially switched over to remote working environments, and that would be um, telehealth from a medical provider's perspective, interviewing folks over Zoom, meetings over Zoom, people working from home, people working from coffee shops, and essentially not going into the office. I think over the long term, many companies have been forced into practicing that or offering their services and dealing with their employees in a remote environment. And I think it's going to continue that way because, frankly, it's a whole lot cheaper in general than having large office spaces. That's not to say that things are not going to go back to normal and people will start be coming back into offices and working together. But I think there's going to be a lot more remote working. And the the primary issue that's come out of remote working environments really has got to do with security. And what I mean by that is when people are working from home or from remote locations, coffee shops, and those kind of things, they don't have the same level of security that they had when they were working in an office. And the information that they may be utilizing, viewing, transmitting, or receiving could be confidential. It could be patient records, it could be HIPAA data. If you have a European operation, it could cover the GDPR under the data protection. And so essentially, there's been a lot of additional risks that companies have taken on. And in general, my recommendations have been to, for my clients to begin to look into using a VPN, virtual private network. They tend to be relatively inexpensive. And essentially what they do is they provide end-to-end encryption of data flowing back over your computer. So let's assume that you're in a Starbucks and you're sitting on your computer and your employee doesn't realize that they're actually not logged into the Starbucks website, but they're logged into a um, a router that, well, sort of without getting too technical, essentially what folks tend to do is they set up a fake um, Wi-Fi login, and people think they're logging into the internet through Starbucks, and they basically all the information is transmitted from their website, I mean from their computer to a third party's computer, who then sort of essentially monitor everything going on, and then they in turn transmit that data to the um, Starbucks router. And so essentially they're capturing everything that's flowing back and forth. And that can happen at home, that can happen at remote locations. So one of the advantages of looking into getting a virtual private network, and again, they're inexpensive, is basically everything that leaves your computer is encrypted, and everything that is sort of transmitted from wherever the information is coming from is encrypted. So if anyone is intercepting that information, that all they get is garbage. So that's sort of a simple way. Other ways are to begin to install remote monitoring software on some of your employees' computers. That may be a little bit more difficult. The question would be, do you own the computers, or does your employee own the computers? And oftentimes you may be looking at using a Mac versus a PC versus a Chromebook. People are logging in from their iPads. So there's sort of a lot of different methods where folks who work for you may be receiving and sending confidential information. Second item of concern is safety at work. So when you bring people back, or you expect people to work at your location, there are some pretty substantial now OSHA claims out there, and guidance from the CDC about what you need to do to essentially provide a safe working environment. And most people are beginning to, or a lot of companies have begun to, enforce social distancing, put up barriers between employees, clean desk spaces, clean computers, and those kind of things. I think that's sort of not only very good, but it also reduces your risk, because one of the questions or one of the issues that you may have is folks are going to get sick. And then the question is, where did they catch the COVID-19? Did they really have a long-term problem with the COVID-19 virus? Is that going to be covered under workers' comp policy or one of your other policies? And that's sort of a complex issue. Essentially, the guidance from the safety at work is you need to maintain good safety practices and protocols regarding COVID-19. I suggest putting together a sort of an internal guidebook and go to the CDC's guidelines. Next issue is COVID-19 vaccines. It's pretty clear out there that generally employers cannot require employees to get a COVID-19 vaccine. There may be some exceptions, but in general, I think it's sort of safe to say that you can't force an employee to get one, even if you think it's the right thing to do. So a lot of employers are essentially coming up with bonuses and those kind of offerings to their employees to get the vaccines. And those that don't, some employers are looking to let those employees go. And that does create a lot of issues associated, depending on what state you're in, but that does create some employment law issues and also unemployment issues. Again, beyond the scope of this, but my recommendation would be to encourage everyone to get for the employees to, if they have an opportunity, to get the vaccines, and encourage them perhaps with some bonuses and those kind of things. The next issue is elimination of positions, and really what that comes down to, and that sort of essentially ties into those folks that have taken out a PPP, a Paycheck Protection Program loan, which if they utilize the money correctly, the loan is waived and it essentially becomes a grant. And during the period that you're utilizing that, you should not be eliminating any positions. If someone does quit, you need to, at a minimum, go through the appropriate process to try and rehire someone during that position. I mean, during that period while you're utilizing the PPP loans. Employee pay. Again, there's some lawsuits coming out of that because as folks switch over to teleworking, they don't necessarily keep track of their time, and the question is, are they working more or less than what you had expected? Are they working overtime, assuming they're not exempt employees? So it does behoove you to basically make sure that each employee essentially comes up with some sort of certification of how many hours they worked during the prior week. Because what you don't want to happen is to have some sort of lawsuit coming down the pipeline in 3 or 4 months later after you've paid these people. Let's assume you just paid them straight 40 hours, and they claim that no, actually they spent a whole lot more time than 40 hours. And if you can have some sort of certification for your employees that they didn't, that's going to help you to the extent they come up with an argument at some point in the future. And most employees actually do work longer than they normally do at work, and they're not very good at keeping time. And so the more you can shift that responsibility to the employee, the better. The ADA does require, the next issue is accommodation of high-risk employees. The ADA does require that you, it does fall under the equivalent of as a disability under the ADA and also under equivalent state laws. And there are not a lot, but there has been some pretty successful arguments made in lawsuits that you need to provide, you need to accommodate high-risk workers. So, reasonable accommodation, for example, would be allowing someone to telework, even if even if all of your other employees are coming back to work. So if someone is a high risk, perhaps they have underlying conditions and they're more likely to get sicker under COVID-19 and they want to work from home, then you cannot necessarily force them to come back to work. You have to at least examine making a reasonable accommodation for them. The next item where folks have begun to make some mistakes is when people want to take leave to care for themselves or care for a family member who has been affected by COVID-19. The Department of Labor has issued some pretty broad guidelines of what you should and you shouldn't be doing, but essentially you need to be able to make at least keep a position open and make a reasonable accommodation for someone to take care of their family if in case they get COVID-19. The laying off of employees, if there's been a large layoff of your employees because business has gone down substantially, there is the Federal Adjustment Retraining Notification Act, WARN Act, which essentially states that you have to provide notice if you're closing down a plant or laying off a lot of people. So to the extent you have or you plan on laying off a lot of people, you ought to be careful of how you're laying off the people, what kind of notices you provide to them, and making sure that when you do lay them off, you're not laying them off based on disability, their sex, their race, or anything else like that, because certain folks are protected or have a little bit more protection than other people within your employment. So you need to be careful of that. Also, certain states, for example, California, have a much stricter rules for laying off people than, for example, Florida does. So just be aware that you could be breaking the law if you're not providing the appropriate um, notifications to your employees. Moving on, real estate issues. So there both landlords and tenants will have some responsibilities with respect to COVID-19. So, for example, there is a general rule out there that a landlord must provide essentially a safe environment for their tenants, and that really has come from a lot of lawsuits associated with people who had been, for example, attacked, women who've been attacked in, in parking lots as they're going home at night, and something happens to them, and a lot of tenants, employees, and visitors have been successful in arguing that a landlord has an obligation and a duty under common law and also under statutory law to provide a safe working environment. So likewise, landlords now have an obligation to provide a safe working environment. So to the extent that your landlord, for example, is not appropriately cleaning the facilities or providing a clean facility, is not requiring masks, notwithstanding the fact that a state may state that masks are not required. My recommendation is, if you're a landlord, you need to have signs up there requiring masks, and if you're a tenant, you need to essentially tell your landlord that your expectation is that they need to provide a safe working environment. They need to adequately clean and disinfect their property, and furthermore, masks need to be required. And the purpose really is to avoid lawsuits from people who claim they may have caught COVID-19, whether they're your employees, your visitors, or other people who may be coming to the building. You need to essentially show that you've done everything that a commercially reasonable business would do under the circumstances. And given the multitude of information about COVID-19, the more requirements you can place on people, whether or not, frankly, they comply with them is a secondary issue. I'm not suggesting that you need to have someone at the front gate of your building or the office of your building and enforcing it. It probably would be beneficial, but even if you don't, you've done what's commercially reasonable and what's expected of a landlord and a tenant. So again, whether you're a landlord or a tenant, take a look at that, the requirements. Next issue that really comes up to is if you have an employee who or a visitor who you know has tested positive for COVID-19, can you go around and tell everyone in your office or tell other people in your building that you have had someone who has COVID-19? I think you can tell if you're, for example, if you're a tenant and you have a breakout of COVID-19 and everyone goes, I believe you do have an obligation to tell your landlord. You should not provide any information about which individuals they are, but you do have an obligation to notify them if someone has been in the office with COVID-19. And likewise, if you're a landlord and you hear that one tenant has had COVID-19, you really do have an obligation to notify the other tenants, at least generally and broadly, that one of your other tenants has, or employee or multiple employees within a within their office has contracted COVID-19, and to give the notice and an opportunity for the other tenants to make their appropriate decisions of whether they want to keep their office closed. Evictions are out there. The question is going to be, can a landlord evict a tenant for failing to pay their rent, and the tenants essentially claiming that because there's either government restrictions on access, or they haven't made enough money and they just can't pay the rent. What are your rights? That's very state dependent, and some evictions are banned, some are not. It depends on what kind of lease it is, whether it's commercial or residential lease, and essentially you need to be careful if you decide to evict someone, and likewise, if you're a tenant, you need to be careful before you claim that you don't have to pay rent. At some point, you may have to pay the rent. The question is, do you have some time between um, when the lawsuit actually starts with respect to the eviction? Um, the COVID-19 has not waived any rights to essentially at some point collect the rent. There are some rules and executive orders that allow certain individuals to not pay their rent. That just doesn't mean it's waived. It just means it's postponed. Um, there are also some lawsuits out there right now where landlords and tenants are making the argument that essentially the government restrictions on access is equivalent to a taking. So they've taken, because they've restricted access, they've taken away your rights that you have in the real estate, and the government needs to owe you some money because, for example, you're a landlord and your tenants can't get in there, and because of the government restrictions, you're losing money. I'm not so sure whether that's going to ultimately be successful, but it does have some legs at the moment in some of the lawsuits. And finally, the force majeure um, provisions. Um, Force majeure essentially says that really means there's an act of God. To the extent that you're either a landlord or a tenant and you're thinking about evicting someone, trying to collect your rent, or not paying your rent, take a close look at your force majeure clauses and determine what your rights are with respect to that. Because I think it's relatively clear now from some of the lawsuits that have been filed that that a COVID-19 is an act of God, and so some of the provisions in your leases may be, and also your loans with appropriate banks and everything else, your commercial real estate loans, there may be some language in there that could be beneficial to you. Moving on. Workers' comp, insurance. So insurance obviously is very, very broad. There's many different nuances to insurance, but there are some workers' comp issues out there. In general, there has been there have been some lawsuits filed where workers' comp carriers have claimed that they don't owe any money to an employee who's contracted COVID-19 because the employee has failed to essentially make the argument that they caught COVID-19 at work. There is a growing presumption in some of the lawsuits out there that, frankly, if you're a healthcare worker, that you did contract it at work, and it's sort of beginning to shift the burden back to the employer to prove that the individual did not get it at work. So my expectation is that if you are involved in the healthcare business and you do have an employee that contracts COVID-19 and makes a workers' comp claim, the carrier is probably going to cover that. And I would expect ultimately insurance rates across the board, but especially for healthcare entities, the rates are beginning to go up, or will go up probably sometime this year or next year. Unemployment issues are another item that's of concern. So, for example, if you have an employee that refuses to come to work because they are worried about catching COVID-19, and they want to continue to work at home, and you essentially take the position that that they are refusing to come to work, and you're firing them for cause, and as a result, they're not entitled to their unemployment insurance. And some employers have been successful in arguing that, but there's been a new executive order that come out under the Biden administration that basically, if you're wary of returning to work, it's beginning to make it a lot easier for an employee to make the argument that they're worried about coming to work, and that if you essentially let them go, you are not firing them for cause, and as a result, they are entitled to unemployment insurance. And in general, there's been more of more of a bias towards allowing employees to collect unemployment. Um, um, so I would say that if you do let someone go, the odds are that they're going to be successful in collecting unemployment. And of course, what that means is that your rates are going to go up at some point in the future. The last item under insurance is the whole business interruption. The initial thoughts coming out from sort of March of last year through perhaps this second or third quarter of last year was that insurance companies were going to be successful in arguing that business interruption would not apply, COVID-19 would not apply, because there are sort of there's language in many business interruption policies to essentially claim that that COVID-19 wouldn't be covered, or that they've excluded it somehow. And there was a big push by a lot of insurance companies and brokers to sort of cut off insureds from making the argument that they should make a claim under their business interruption policy because of COVID-19 and they've lost money, and as a result, they should make a claim. There's been some recent lawsuits coming out of London against some Lloyd's policies that actually have overturned that position. So I'm not so sure where it's going to go down. I think a lot of it needs to be is very, very dependent on your policy. So read your policy carefully and don't assume that your broker or your insurance company is telling you the truth, that it is absolutely excluded. Probably the best advice I can make to you is file a claim, because one of the most important things is the timing. And if you have, for example, 90 days, 120 days, or a period of time, you have to essentially file a claim within a reasonable amount of time. And if you fail to file the claim, then you may not even get to the point of arguing with your insurance company of whether or not it's a covered claim. So if there's some sort of if you believe you have at least a legitimate argument to make a business interruption insurance claim, file it, because at least at that point you've cut off the argument that you failed to make a timely filing of the claim, and then you can get to the meat of the matter of whether or not it is a covered claim. And frankly, even if they deny it as a covered claim, you may have some point, depending upon what the lawsuits and some of the ones that are working their way through the systems now, you may end up being able to go back and dispute that and get some coverage. So to the extent you feel like you have lost a lot of money and you may have appropriate business interruption insurance, file a claim. Covered that real estate issues. Telehealth. So telehealth was very, very difficult, frankly, for a lot of employers, healthcare employers. A lot of people did not use telehealth. The government had a lot of, frankly, stupid rules out there that prohibited telehealth. They didn't prohibit it. They made it very difficult. The first patient interaction had to be in an office, and then the second one had to possibly be, you could be a remote location, but the patient had to be at some other location. They couldn't be from home, and a lot of the federal government has issued a lot of waivers for healthcare providers, essentially allowing telehealth to really bloom. And I think that's really going to make a big difference going forward. I don't believe those waivers will be taken back. I believe that telehealth is the future, and physicians and other healthcare professionals need to get used to conducting business over a computer. So I would expect to see substantial growth in that. But it does raise a couple of issues. Network security is probably the most important. Is what kind of security? Who is providing the telehealth platform? Encryption is pretty important right now. The rules have been waived on encryption, so to the extent you're using something where you don't have end-to-end encryption of the data, you're okay. But I believe that at some point that's going to come down, that you do need to have end-to-end encryption, which means that if anyone intercepts the video transmission, it would be encrypted and they wouldn't be able to view it. So I begin to look at what providers such as Zoom and those other folks, whether or not they provide end-to-end encryption, because I think that's going to be pretty important. Second thing is you need to begin to expect that your video session is going to be viewed as a digital record, as a patient health record, and as such, you're going to the extent you have electronic health records, the question is, can you attach that video recording to your patient health record? And video takes up a huge amount of data and can increase your expenses. So I would expect, and I would plan for, contacting your electronic health record company, finding out to what extent do they allow the attachment of video. Look into whether or not your patients are comfortable with you saving that video encounter, because some may not be, and there are some issues about whether or not they do need to provide their consent. And if they don't provide that consent, the question is, do you have the issue to override that? And that really depends on a lot of things, everything from what you're going to be discussing, for example, AIDS or sexually transmitted diseases, mental health, those kind of things, versus I have a sore throat and I need some assistance because I'm feeling under the weather. There are different rules when it comes to that. So you need to be aware of that, but you need to plan for, at some point, my expectation is that a lot of video records would be attached to your electronic health records, and the pricing and the fees may go up as a result. And of course, that information does need to be encrypted whenever it gets saved. And these days, frankly, it does get saved on the cloud. So you need to make sure that your cloud provider is HIPAA compliant. PPP. So many different entities have taken out PPPs, payroll protection programs. There's been two tranches of money. The first one was last year. The next one is currently ongoing. The first round of funding got off to a very rocky start. My experience with providers from the second round of funding is it's working pretty smoothly, and the money's generally, assuming you meet the requirements, is funded within a week or two. The forgiveness of loans is actually, even today, is a bit of a moving target. It's relatively clear what you need to do to get the forgiveness of the first tranche. The second tranche, the rules are out there, but they're not finalized. But obviously, work with your accountant on those, and the bank, and filling out the appropriate forms to make sure the loans are forgiven. Keep copious records. That's very, very important, because don't forget, the person who's going to be reviewing your request for the forgiveness of loans is going to be generally a bank employee, mid-level bank employee. They're going to have a checklist of what's going to be required. And the more information you can provide to them, the more comfortable they are that they can actually check the box to say they've received this and the money was spent in this way, as opposed to a different way. And to the extent you get audited by the SBA or any other state entity, the records that you keep on where you spent the money, how you spent it, did it go to employees, did it go to pension plans, did it pay off, did it go towards rent, did it go towards utilities and everything else? Keep copious records, because otherwise your PPP is not going to be forgiven, or you're going to get into an argument with your lender, and then essentially it becomes a loan that's payable over a certain number of years, which isn't the end of the world, but it's a whole lot nicer to get the money forgiven as opposed to having to make loan payments over the next 4 or 5 years. Don't forget during the period where you're utilizing, and there's a period after where you're utilizing your PPP monies. There are limitations for laying off your employees. So, and to the extent someone quits, post the job and begin hiring, don't sort of take the position that, well, since they don't work for me anymore, I don't have to fill it, and now I can save money. Obviously, if you can't find the right person, that's fine, but you need to make at least a commercially reasonable effort to hire a replacement employee. The final item that's popping up a lot these days is if you're planning on buying or selling a business that has an outstanding PPP loan, there are some pretty onerous rules that the SBA has put out there. So be aware if you are selling a business that has a PPP loan or you're buying one that has a PPP loan, and assuming the forgiveness has not been the loans have not been forgiven, there are some pretty onerous requirements for essentially putting aside the full value of the loan into an escrow account, notwithstanding the fact you've actually already spent the money, and then you will be allowed to close, which obviously makes things very difficult. So the sooner you can, if you are planning on especially if you're planning on selling a business, the sooner you can get that loan forgiven by your bank, the better. That will avoid a lot of putting a lot of money into escrow. And the final item on my discussions today is lawsuits. There was a lot of talk about a huge number of a huge number of lawsuits that were going to be filed in 2020. It's been a whole lot smaller than expected. The lawsuits are really coming out of business interruption, where a company claims that COVID-19 has interrupted their business and they need to make an appropriate claim. Those that have been absolutely successful are entities that have sort of, for example, rock bands who had business interruption and they could no longer hold an outside concert. They were successful in collecting money. Other entities have been sort of somewhat successful. Restaurants that have been forced to close because of COVID-19, or they've lost a lot of business because of COVID-19. Some have been successful, some have not. Again, the landscape is very unclear at this moment, but if you do have a possibility of making a claim for business interruption, I would strongly recommend that you go ahead and make it. The next one is workers' comp coverage. Again, generally, if you're in the healthcare field, to the extent that someone collects or makes a claim for COVID-19 under the workers' comp, they are generally covered. If they're not, it's sort of up in the air, and a part of the analysis is going to frankly come down to even if it's initially denied, is what kind of other health insurance is covered, and what kind of other health insurance does the employee have. Can the employee essentially argue that they've been home the whole time and the only time they ever go out anywhere is if they go out to buy food and that kind of stuff, and they wear masks and everything else, but the majority of their time is spent perhaps working for you in your office, then the burden may be shifted back to you. So again, it's a moving target. It's unclear whether it is or it isn't going to be covered, but if your healthcare provider is more likely it will be covered as a workers' comp claim, and as such, I would expect premiums to go up. There have been some successful lawsuits out there on the wage and hours, basically working from home, and you did work more than 40 hours, your employee refuses to pay you, and for that amount, and some workers filed appropriate claims, and they've been generally successful. Disability, people are beginning to make disability claims, some especially with the long-term problems they've had with COVID-19. Some people, even months later, are still sick and don't have any energy and those kind of things. And then, did an employee make a reasonable accommodation? Again, employees should not be absolutely forcing people to come in to work, they need to take a long, close look at who's coming in, what's the reason why they're bringing them in, is it a safe environment they're bringing them into, or is it safe for those people to stay at home? And the argument that, well, I think it's better when everyone works together in my office, frankly, doesn't carry a lot of water at the moment. Safety is first, and to the extent you as an employer can minimize your risks, um, um, my advice would be to allow people to work from home. Let me see. And that is the end of the initial discussion. There are a few people on, and if you have any questions, please feel free to submit them now via chat. If not, I will wrap things up. You have my telephone number there. I'm available 7 days a week. I tend to work on weekends and stuff like that. So to the extent that you have any questions, please feel free to email me. I'd be happy to help you out. I know I've covered a lot of information, but and frankly just touched on it. And I could probably spend an hour or two talking about every single one of those pages. But to the extent you have any questions, send them to me now. And if not, I appreciate you taking the time to listen to me. And I wish you stay safe, get vaccines when you can, and let's hope that 2021 is going to be a safer year than 2020.